When it comes to making gifts of assets, sometimes people might identify personal use assets that they may want to give away to future generations. But that can cause estate tax issues that we're going to look at here today. So this is a presentation first and foremost for attorneys and advisors who want to understand some of those surface tax issues that come up when you transfer personal use assets to family members, and also for individuals who might be contemplating this type of transfer to reduce what they might see as their potential estate taxes in the future. What we're going to find out is that gifts on paper, like changes of title, aren't necessarily binding for estate tax purposes. So, for example, if you take the most classic personal use asset of a residence and you change title but keep using it, the IRS can treat you as the owner when the estate tax bill is due by your estate. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. Today's episode 222, is a surface-level dive into a classic Revenue Ruling 70-155, which was concerned with the use of a gifted residence by the original owner. As always, this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only. A little bit about me. This is not an advertisement for legal services, but I am an attorney with the law firm of Hutchins & Associates in Denver, Colorado. What I do provide above and beyond that is tailored estate planning and tax education to a wide variety of interested people and groups. So, if you'd like to retain me as a speaker or leverage estate planning education as a differentiator for your firm, practice, or organization, you can reach me at griffin.bridgers@gmail.com. Now back to the presentation. In prior episodes, I've talked about a couple of tax principles which can essentially act to ignore gifts or lifetime transfers for estate tax purposes. So what happens is if either of these tax principles apply, then the IRS looks not to the ownership of assets, but instead to your personal relationship with assets and your use of those, and treats you as if you owned that property, even though you might not hold title to that property. So where this kicks in is in any type of asset that you've transferred during your life. So in order to have an issue here, you have to have once owned an asset and you have to have transferred it to somebody else. And these two tax code provisions, 2036 and 2038, could kick in looking at if, even though you are no longer the owner at death, you have the same type of arrangement that looks like you are still actually the owner. So, 2036 has two testing points, both the time of transfer and the time of death. So, if you transfer an asset like your residence but keep living in it until death, the IRS could ignore that transfer. 2038 looks to a situation where maybe you once owned an asset and transferred it, but at your death, you would have reacquired some right of use or benefit. So that would be more the case if you once owned your residence, you transferred it to somebody else, then at some point in the future, you moved back in and started to use that residence, and that use continued until your death. Now, what we're really concerned with here is 2036. We're going to be testing this both at the time of transfer and at the time of death. So what 2036 is concerned with in the actual words of the tax law is retained quote-unquote possession or enjoyment of a property that you transfer during life. Now, there is a narrow carve-out for that where there's a bona fide sale. Now, in order to have what's known as a bona fide sale, this isn't just simply a sale of the asset to somebody else. We're not just comparing gift versus sale. What we're doing here is looking to whether you sold it for at least the fair market value. So, if there's any discount on the purchase price, 2036 could kick in. And this is only an issue, too, if you don't pay rent for the use of property after you transfer it as well. So if you give, say, your residence to somebody else and continue to live there, but you pay full fair market rent to the new owner, 2036 isn't going to be an issue. There is a carve-out for a bona fide sale. Now, It's important to note, too, that what we're looking at is a formal change of title, and the retained possession or enjoyment doesn't have to be in any sort of formal or enforceable, legally enforceable arrangement. It could be a simple implied understanding between the original owner and the new owner. It could just simply be that the new owner is afraid and doesn't want to kick the old owner out of the residence post-transfer. So what we're going to do is use this lowest hanging fruit, the form of a residence, to illustrate how this works in the context of a pretty significant IRS revenue ruling, 70-155. Now, the 70 is the year that this came out, 1970, so this was over 50 years ago, so this has been a long-standing principle. So what happened is, in this revenue ruling, the IRS applied Code Section 2036 to determine that there was an implied understanding that there'd be retained possession or enjoyment of a residence when there was a situation where, one, the father transferred title to a residence to son and to daughter-in-law, but after that transfer, father never moved out. The father continued to live in the residence post-transfer without paying rent or utilities or taxes or repairs or maintenance or anything like that. So the key principle here that is implied, pun intended, that's expressly stated in later cases that kind of built on this ruling, is that the father's continued use and refusal to move out essentially denied the son and the daughter-in-law their own occupancy of the residence after the transfer. So that's really kind of the key principle that came into play when we look at what is an implied understanding of retained possession or enjoyment. It could simply be fear, and it could simply be the fact that it's inconvenient to co-occupy the residence with the original owner who has refused to move out. Now, there is a twist to that, in that co-occupancy by old owner and new owner may just be natural in some cases. Case in point would be a marital relationship. What was acknowledged in this revenue ruling is a carve-out from another tax court case from 1966 called Estate of Gutchess, which said that when there's a transfer from a spouse to another spouse of the residence, there isn't an automatic assumption that there's an implied understanding that there's retained possession or enjoyment, mainly because it's a natural outflow of the marital relationship that the continued use and occupancy by the original owner spouse wouldn't deny the new spouse of their own co-occupancy, because it's natural that a married couple would co-occupy a residence both before the transfer and after the transfer. So it's this deprivation principle that really comes into play here when we look at that. And we'll talk about that and touch on that in a second. But if you're big into legal procedure, the only significance, this isn't a blanket rule by the IRS or the tax court saying, hey, there's never going to be any 2036 issue if there is co-ownership between spouses. Really, all it does is it shifts the burden, because 2036 really kind of assumes an implied understanding anytime there's a transfer between family members, and it puts the onus on the original owner or the original owner's estate and not on the IRS to prove that there was an implied understanding. Instead, there's an assumption of an implied understanding that the estate of the original owner now has to come in and disprove, which can be a heavy burden. So some of the implications of this relating to that heavy burden scenario is that while this is still unsettled and there are many moving parts, this could, for example, support a transfer of a residence, let's say, to a slat, where maybe the settlor of that trust retains the right to occupy the residence even though the settlor is not a beneficiary. And the hope is you can avoid a 2036 issue with respect to the slat, at least for the residence, and maybe with respect to the entire property or principal of the slat. Now, All this is avoided if the original owner who retains occupancy post-transfer pays rent to the new owner. So if you're paying rent, it's not an issue. It's only this free use that is at issue here because the economic arrangement doesn't correlate to the change in title. Even though title is changed on paper, the actual arrangement hasn't changed. It's as if the original owner still owns the house because they've kept living there. They're not really paying rent. They're not acknowledging the change in ownership. Nothing has changed on their end. So the rule for spouses here is not universal. The retained income, for example, if it's an income-producing property and not a personal use property, could create that implied understanding. So this is kind of narrowly focused on personal use assets like a residence when we look to spouses versus non-spouses. And similarly, there are blips in the radar too when you look at non-spouse ownerships. So for example, courts have on occasion declined to apply 2036 to find an implied understanding where there's continued occupancy of a residence post-transfer to a non-spouse family member. But the key there is that really that's a shift of the burden where it's on the estate of the taxpayer who was the original owner to prove that there was no implied understanding. So in these blips, what's happened is that the estate of the taxpayer has been able to successfully prove that there was no implied understanding that there would be continued possession or enjoyment of the residence post-transfer. As always, if you have non-legal advice questions or topic suggestions, you can email those to me at griffin.britters@gmail.com. But as I remind everybody, I cannot answer client-specific questions or offer legal or tax advice. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.